Hello, I'm John Carlson. I am the director here at the Center for the Study of Religion and Conflict, and I am delighted to welcome you all here today for our very special Jonathan Maxine Marshall Speaker Series in Religion and Conflict. Our speaker this year is Professor Cathleen Kaveny. So we're delighted to have her. As many of you know, this year is a special year for us. We are marking our 20th anniversary this year, and we're doing some special things. So I've got a little balloon bouquet here to celebrate, and I just want to assure all of you that there are no cameras in this any of these balloons, right? When we want to do surveillance, we just set up a camera in the back and do surveillance. So you can see it right there, and hello to all of you at home who are surveying us from your couches and your living rooms. So, and because the Chinese government was apparently a little bit annoyed about their balloon, we thought we would just donate these after we're done today. So, okay, a few housekeeping matters. Before we get started, if you would, please silence your cell phones. Also, mark your calendars for a few upcoming center events. The first is the day after tomorrow, Saturday, February 11th, 4 p.m. at the Alumni Lounge. That's where we had our event last month. There is an event called Faith in Football, Mercy, Forgiveness, Patience, and Prayer in Sports, in anticipation, of course, for the Super Bowl the following day. And it's going to feature two former NFL players, Hamza Abdullah and Matt Ware. So I encourage you to attend that. That's going to be sponsored by the ASU Center for Muslim Experience in the United States, and we're co-sponsoring that event. On Thursday, February 23rd, 3:30 in West Hall, the center will welcome John Modern for a lecture on religion science, a devolved manifesto, drawing out on our speaker's study of religion, the brain, on post-punk art, and many other great things. And that's part of our Beyond Secularization project. And then finally, on March 30th, we'll be hosting Wesley Lowery, who, if you don't know, is a former journalist for 60 Minutes. You may have seen him on television, also the Washington Post. He has a new book that's going to be coming out. More details to follow about that, but do please save the date. You can find out information about all of our events on our website. You can get access our YouTube channel for any past events that you might have missed. You can also follow us on social media, on Facebook, Twitter. We now have Instagram. We are so hip. We are not on Truth Social. But there's still other ways to reach us, right? Okay. Lastly, please, after today's event, join us downstairs for a reception in the bistro. It will be lovely. We'll have an opportunity to continue any conversation we're not able to have here. Actually, I do have one more announcement. Dawn, could you poke your head out, just see if Carolyn's out there? Some of you may know this already, and I would be remiss if I didn't say this, but after 20 years, as a founding member of the Center for the Study of Religion and Conflict, Carolyn Forbes, our assistant director, is going to be leaving us. It's very sad for all of us. We have been so blessed and so fortunate to have her, and none of us would be sitting here right now if it weren't for all of the work that she's been doing, that she started back 20 years ago to build this center, really from the ground up. So I promised Carolyn I wouldn't say a bunch of things to embarrass her. She is a humble servant, a happy warrior who carries on. So I'm just going to share just one observation that's relevant, because some of you have shared this with me. People have asked me, how will you replace her? And I just want to be very, very clear. We won't. We can't. Okay? Carolyn is sui generis, and if we brought someone in to try to do all of the things that she's been doing over the last 20 years, we would be setting that person up for failure, right? It's just not feasible. It's not fair. But I want you all to rest assured that all of the things that she has been doing will continue to be done, even if it takes several people to help do this, fill out those roles. And we will have complete continuity of operations. We will flourish, we will thrive, as Carolyn would want us to do, of course. I know she'd want nothing less. So for now, just on behalf of everyone here in the room, Carolyn, and on behalf of the hundreds of other people who have been impacted by the work at the center, I just want to thank you. So, and these flowers are actually for you, Carolyn, or bouquet is actually for you. So I needed to get it off of the podium. So.
Thank you.
Chinese-made balloons, I guess. They fall off here. Okay. All right, on to our main event. Today's lecture is part of the speaker series that's been established here since from the very early days of the center. It's an endowed lecture by the donors Jonathan and Maxine Marshall, who endowed this lecture series as a reflection, really, of their desire to address issues of conflict, to enrich our civic life, but to do so through dialogue and through civic engagement. So today we're going to be talking and hearing a lot about religious liberty, which I think, as most of you know, is a very pertinent topic. This language of religious freedom, liberty, has always been part of our history and a dynamic force in politics and in law, how we imagine ourselves, how we imagine our founding, etc. And they also have a way of provoking and helping us to think about what the role of religion is in public life. And I would just draw your attention to, say, the last 60 years or so, in ways in which religious arguments have been on both sides of different issues such as racial discrimination, gender equality, gay rights, health care, abortion, death penalty, many, many, many other things. And many of these issues have, particularly what we call culture war issues, recently turned on the matter of religious freedom. So against this backdrop, we're very fortunate to have Cathleen Kaveny to help us really understand this. She is the Darald and Juliet Libby Professor at Boston College, where she has joint appointments in the Theology Department as well as the Law College at the School of Law. Her research focuses on the relationship of law, religion, ethics, medical ethics, and she's the author of 4 books, more than 100 articles and essay. I'll just give you a couple of samples of her books. One is entitled Prophecy Without Contempt, Religious Discourse in the Public Square, and another is Ethics at the Edges of Law, Christian Moralists and American Legal Thought. And she's currently working on a new project that sounds absolutely fascinating. We'll have to have you back when that one's done to talk about it, on the politics of nostalgia. She holds both a Ph.D. in moral philosophy as well as a law degree, so she embodies well what we understand in this country is the importance of both the separation of church and state, but also the understanding of the far more complex relationship between religion and political life. So we've had a wonderful visit here today. I feel very honored and blessed that we could be the first stop on the site and reason for the first visit for Professor Kaveny to come to Arizona. So, and you picked a great time to do it. So, if you would, please welcome me and please join me in welcoming Professor Cathleen Kaveny. Her talk today is Religious Liberty After Dobbs.
Well, I'm absolutely delighted to be here in Arizona. It's my first time to your beautiful state and your wonderful campus, and I am just so grateful to be honored with the invitation to be the Marshall Speaker this year, especially the year of the 20th anniversary of the Center for the Study of Religion and Conflict. I feel in the past couple of days that I've gotten to know people at the center that this is just a wonderful place with wonderful people to consider very hard issues with mutual respect, looking at the nuance and looking at the way in which we can disagree in good faith, still seeing the sides of the argument that may not be the most persuasive to us personally, but are persuasive to people that we're called to live in community with. And I think that as a work of a university and as a work of a center like this is at the heart of what we need in these very, very troubling, sometimes difficult and overheated times. So again, thank you very much to Professor Carlson, to Professor Forbes, and to Professor Fessenden for inviting me to participate. So my talk is on religious liberty after Dobbs versus Jackson, which is the new abortion decision. But before we get there, we need to do a little bit of preparation. And after we get there, after I go through the whole talk, I'm not coming up with the big answer to things. I don't think any one person has the big answer. I'm looking forward to talking with you together as fellow citizens of of this great country of ours about how we might look at these challenges. But I want to start by talking about a case from over 100 years ago involving the Church of Latter-day Saints, sometimes called the Mormons. In 1852, the leaders of the Church of Jesus Christ and Latter-day Saints announced and defended the practice of plural marriage, sometimes called polygamy. It was actually practiced publicly in that community from 1852 to 1890 by between 20 and 30% of Latter-day Saints and their families, usually practiced by those men who were wealthier and more powerful because they had the resources necessary to support more than one family. But that practice was frowned upon, to say the least, by the broader American public and the broader American legal system. In 1862, the Moral Anti-Polygamy Act was signed into law by President Abraham Lincoln, and it prohibited the practice of plural marriage in all U.S. territories. And Utah, at that point, was not a state, but a U.S. territory, so it applied there. Now, many members of the Church of Jesus Christ and Latter-day Saints did not simply acquiesce to this prohibition because they believed that the law impinged upon their moral duty to practice polygamy. So what do we get when we have somebody who feels they've got a duty and the government who says, oh, you've got a duty, but it's in the other direction? We get a lawsuit. That's what we get. And so there was a case called Reynolds versus United States and decided by the Supreme Court in 1878. And the plaintiff, Mr. Reynolds, was charged with violating the Anti-Polygamy Act in Utah, a federal territory, and he said, he defended himself against the charge by saying that polygamy was required by his religious beliefs, and the First Amendment to the American Constitution protected him. The defendant, the U.S. government, said, we don't think so. We think it's within the right of every government to determine the form of marriage acceptable within its society, and polygamy has long been condemned in the English and in American legal history as leading to, sexual excess and to degrading the equality of women, which they were concerned about at that point. Some might say not concerned about at other points, but that's a lecture for another day. So before I go further, I just want to take a little straw poll. Pretend you're a member of the Supreme Court back in hearing Reynolds versus Massachusetts, and you have to decide whether to protect the Reynolds' right to exercise polygamy in accordance with their religious beliefs on the one hand, or protect the government's right to organize family life and set forth obligations on marriage on the other. How many of you would have said, religious liberty trumps, we go with the Reynolds? Put your hands up when there's no taping here, unless you're running for, Congress next. Okay, so a few. How many would have gone with the government and said the government has to be able to regulate these practices? A few more, right? A few more, not total. And then the rest of you are simply going to just wait and be born today and see what happens, right? Good choice. So we know that was the case. What happened? Well, what the court said was this. Laws are made for the government of actions, and while they cannot interfere with mere religious beliefs and opinions, they may with practices. Suppose one believed that human sacrifice were a necessary part of religious worship. Would it be seriously contended that the civil government under which he lived could not interfere to prevent a sacrifice? Or if a wife religiously believed it was her duty to burn herself upon the funeral pyre of her dead husband, Would it be beyond the power of the civil government to prevent her from carrying her belief into practice? So what the court said was, we understand you have a right to believe in polygamy. You have a right to agitate for the legalization of polygamy, but you don't have a right just under religious freedom to practice polygamy as you see fit. So let's put this case in a little bit broader context. It took place well over 100 years ago, but the questions it raises are still with us today. In fact, they're even more complicated because our society is even more religiously pluralistic than things were back in the 1860s. So this raises in acute form the question considered in Reynolds. How do we recognize the right under the Constitution of representatives of our duly elected majority to make law, which necessarily involves moral judgments, even religiously based moral judgments that some people might not share in a pluralistic society? Doing that on the one hand, while also on the other hand, recognizing the constitutionally protected right to free exercise of religion of those who live in the land but may not agree. So that's sort of the big question I'm looking at in today's lecture. So I'm going to explore the questions a little bit to give you some context, and then talk about it in a new variation that is developed as a result of the past 6 months or so, 8 months or so of constitutional law. The decision on the part of the Supreme Court in a case called Dobbs versus Jackson to overturn Roe v. Wade, which had protected a constitutional right to abortion, and return the matter of regulating abortion to the states. So that's going to create a little bit of a complicated picture for questions of religious liberty. And as I said before, I don't have all the answers. What I'm hoping to do here is to kind of identify some of the questions, and maybe we can talk about them together. So what are some of the questions? Well, question one really is, what do we mean by free exercise of religion? The First Amendment to the Constitution protects the free exercise of religion. What is it? Well, let me begin by just reading the First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, of the right of people peacefully to assemble and petition the government for a redress of grievances. So you see that First Amendment, which talks about free exercise of religion, has a lot of other stuff in it, including freedom of assembly and also freedom of speech in particular. Well, what does the religion clause or the religion part mean? Well, the federal government can't make people go to church or mosque or synagogue or temple. It can't tax people or harass them or imprison them on account of their religious beliefs. It can't say this state is Congregationalist or Catholic or Mormon. Now, actually, the First Amendment, as it first started, only applied to the federal government. So there were states that had establishments well into the 20th century. But by the mid-20th century, the Supreme Court has said, you know that religion clause thing about the government? We don't mean just the federal government. We also mean the state government. So right now, neither state nor federal government can establish a religion. That's called the Establishment Clause. And that's very important, but it's not our focus today. Our focus is what's called the Free Exercise Clause. And that says that proclaiming any opinion in any matter of religion, no matter what it is, will not affect you in your civil capacities, in your capacity to vote or to serve for higher office. You can advocate for polygamy. You can advocate for human sacrifice. You can advocate for anything you want as a matter of religion. You just can't practice it. So in a nutshell, let's think about what the Free Exercise Clause might mean. So let's approach it by thinking of a sphere with different layers, 3 different layers, like a model of the globe. Let's pretend at the very core of that sphere you have got a blue core. It's a blue core right in the middle. Then surrounding the blue core, let's say you've got a purple core, okay, a little blue circle, a purple circle surrounding that, and on the outside you have a red circle. Or if you're more of a food-based learner, think about an almond joy, right? The center is the almond, right? You got the almond at the center. Then you have the coconut goodness around the almond. And then you have a layer of chocolate surrounding the whole thing. So you can either do the color approach or the almond joy approach as we go through my analogy. So let's start with the core of the sphere, the blue core, or the almond in the almond joy. As I just said, that's the freedom to believe whatever religious doctrine you want. And you can espouse those beliefs in public too. It's no accident, in my view, that the First Amendment includes both freedom of religion and freedom of speech and freedom of assembly. You can express your religious beliefs alone or in community, in assembly, by speaking them without fear of penalty. So we'll call this the almond at the center of the almond joy, or the blue core of our 3-layered sphere. It's really the heart of what religious liberty means. But is there a second level to this? Is there a second sphere? Yes, and I think that that's freedom to engage in ritual worship, right? Many religious traditions say that it's not just important to espouse a belief, but also to enact them ritually in communion with others. So think of this as the second layer. In our circle, it's the purple layer, right on top of the blue layer. And in our candy bar, it's the coconut layer. And most religious belief requires some form of ritual observance. You may say, fine, what's the big deal? But sometimes ritual observance can involve behavior that's a little bit problematic, that a large group of people believe is not morally acceptable. In the era of Prohibition, for example, people thought the use of wine, any kind of alcohol was problematic, but it's used as part of the celebration of the Eucharist for many Christian denominations. The use of psychogenic substances in Native American rituals, such as peyote. We've got had a whole set of anti-drug legislation. There's a clash between that behavior and actually what the law says. So you don't need to go all the way to human sacrifice. We actually have some interesting tensions right here among us. So if you think about the mixture or the ritual level, you can see it's kind of a mixture, right? On the one hand, most of the time, it reflects religious belief. If you go to a religious service, there's an awful lot of talking, at least in many of them, or behavior that's not objectionable, such as sitting quietly. But at the same time, rituals include actions, and sometimes they have a significant effect on the world, our day-to-day world, not simply the transcendent. And sometimes they involve behavior that is clearly against the rules. So how do you think about them? Well, we might just go to action, thinking about how do we regulate action. I'm making a case for thinking of ritual as a little separate category, though, because ritualistic actions are actually bounded actions, right? Nobody, a 6 or 7-year-old little Catholic girl may go up to communion and get a sip of wine. That does not mean that she's, jugging box wine while, watching TikTok, right? So the ritual bounds the use of the behavior. But that's not always the case. We have to go to the third layer, which is just sort of general action. As we saw with the LDS, for many people, religion and religious belief isn't simply a matter of abstract belief or even a worship service on the weekend. nor is it a matter of what people do within the confines of those services. It also affects and is meant to affect their actions in their day-to-day lives. Many people who are religious think that their religious activity motivates them to engage in certain kinds of activities, sometimes service to others, sometimes civil rights work, sometimes working with immigrants at the border, sometimes charitable work. Religion, in many traditions, isn't just a matter of what you say, it's a matter of what you do in broad spheres of your life. In fact, many religious belief systems have codes of conduct talking about what behavior is good and what behavior we should avoid. And in our own day, of course, that's as true as ever. So the hard question about religious liberty is really how far up in our circles or from the almond to the chocolate, or from the blue up through the purple to the red it reaches. Does the constitutional commitment to the free exercise of religion mean that one is free to refuse to engage in activity that the community requires, justifying one's refusal on religious grounds? Or does the constitutional commitment to the free exercise of religion mean that one is free to engage in action that the community legally prohibits, justifying one's activity on religious grounds? So that's where we are. We're looking at not religious belief per se or even ritual, but at religiously motivated, conscientiously motivated action. So how are we going to handle that? How do we adjudicate freedom of religion claims when it comes to broader action? So there are two basic approaches in the law that are going on right now, and I'm just going to tell you a little bit about each of them. Approach one is found in a case from 1990, and it's called Employment Division versus Smith. And this approach kind of echoes what we saw in the 19th century polygamy case. It draws a sharp distinction between belief on the one hand and action on the other. And it says you are free to believe and to preach whatever you want, but you are not free to act according to those beliefs if it violates a generally applicable law. And the approach was developed in a case that actually involved the use of peyote. The Smith case involved a man who was denied unemployment compensation benefits for having been fired for having engaged in an illegal act, smoking peyote in a religious service. But he didn't just smoke peyote for fun, obviously. He smoked it in the context of a Native American religious rite. So he argued that in denying him unemployment benefits in this particular context, because he had smoked peyote in a religious context, the government was impinging upon the free exercise of his religion. Writing for the court, Scalia channeled the main opinion in Reynolds from the Mormon case. He said that laws of general applicability, like laws against the use of psychogenic substances, did not violate the First Amendment, provided that they did not specifically target the practitioners of a particular religion. So if you are fine, say, with animal sacrifice in general, but you don't like the people that are practicing it for religious reasons, and you pass a law saying no animal sacrifice, in that particular context, and it's clear that you're just targeting the religion, this case would say no go. You are violating religious freedom there. The key is if you have a generally applicable law that has a side effect of impinging upon religious belief, Justice Scalia says the First Amendment is not going to stop you. But he also said that the legislator has options. You can petition the legislator to make an exception to your general rule. So the Volstead Act in the era of Prohibition made an exception for the use of alcoholic beverages in the context of religious services. And so what eventually happened is the state of Oregon made an exception for the use of of psychogenic substances in the context of religious services. And you may say, oh, that's great, that's wonderful. But it's pretty clear that more powerful religious groups like Catholics would be able to get the exemptions they wanted a lot easier than more liminal and more ostracized and smaller religious groups, sometimes like Native American populations. So people noticed that when when the Smith decision came down, and it provoked an outcry. But it also provoked unanimity. Everybody on the right and the left thought the Smith decision was wrong because it did not protect religious liberty enough. And what people were worried about at the time, the more progressive people, was the small groups like Native Americans or people who were engaged in non-Christian practices who didn't have the political clout to get the exemptions they needed. So everybody got together and passed a law called the Religious Freedom Restoration Act of 1993. So where we are right now, Smith, the law, kind of generally applicable, no discrimination, that's what governs the Constitution. But there's this other law that came into being that governs federal regulations and federal law. It tried to make itself like a constitutional amendment, but our Supreme Court said, you know what? You guys don't get to interpret the Constitution. You're just Congress. It's a federal law, no matter how you dress it up. So it's a law, but it's a powerful one. It was meant to make it harder for the federal government, including federal laws and regulations, to restrict religious freedom, especially religiously motivated action on the part of religious people. It thought of itself as restoring a more stringent test that the Supreme Court had applied to religious liberty cases before the Smith case. So as I said earlier, and it's important to emphasize this, RFRA only applies to federal law and regulations. It's not the law of the First Amendment, which was Smith. But the other point to emphasize is some states do have their own religious freedom restoration acts, including your own state of Arizona. And so basically, even though the federal RFRA doesn't apply to states, the states have enacted, very almost identical laws. So you're stuck with this as well, but under state law, not federal law. And the other thing that I'm going to show you in a little bit is it's not as if RFRA and the Smith test don't talk to one another. So the Smith test is the test for constitutional law, but as time has gone on and as the membership of the Supreme Court has changed, you see a more and more religiously protective interpretation of Smith. Even though originally it wasn't that, the Religious Freedom Restoration Act is sort of seeping back into the interpretation of Smith. So, we got to talk a little bit about Smith. This is the most legalistic I'll get, so just bear with me and it'll make sense in a minute. What does Smith say? I mean, not Smith, rather, RFRA. God, I'm getting you confused because I'm getting me confused. RFRA, the Religious Freedom Restoration Act, says that a law of general applicability that a claimant sincerely experiences, I'm a claimant, I sincerely experience that law as burdening my religious freedom, needs to be justified by the government showing that the law imposing the burden serves a compelling state interest. Most laws are just rational basis. If you've got an interest, you can legislate. It has to serve a compelling state interest, and it has to be the least restrictive means of advancing that interest. That's a mouthful, right? That's a huge mouthful. So let's break it down in practice with a recent case that's been in the news that did involve religious freedom and abortifacient contraception is what they called it. There's a case called Hobby Lobby versus Burwell. I don't know if you remember that case. And in the case, religious believers who owned a closely held corporation, the Hobby Lobby Corporation, they challenged federal regulations requiring them to cover certain kinds of contraceptives, which they said violated their religious beliefs because they were against abortion, and they felt that these contraceptives prevented the implantation of a fertilized egg, which in their view was a very early abortion, but it was an abortion nonetheless, and they didn't want any part of it. And so the Supreme Court took up the case. And in doing so, it had to analyze the Hobby Lobby people's claims and the government's claims. And what was really interesting was how the analysis worked. Well, the Supreme Court pretty much took for granted that the plaintiffs were sincere in their objections to this. They said they were sincere, they were filing a brief, they were spending a lot of money. And in fact, in most cases, the courts do not question the sincerity of plaintiffs. Sometimes it's pretty obvious, like, so if you get prisoners who are incarcerated and they say, well, I belong to the Church of Beer, Pizza, and Football, and you need to provide me with all that Fridays and Monday nights, the court says, no, you're not really sincere. You just like beer, pizza, and football. That's a good thing, but it's not a religion. And they also, the Supreme Court, accepted at face value the claim that their religious belief was substantially burdened, which was a bit tricky, right? Because nobody was forcing the Hobby Lobby people to actually give the pills to the women, right? Or go to the drugstore and pick them up. They were just had to pay for an insurance package that covered that. So it's pretty remote from the actual act, but the court said, you know, who are we to tell people how sensitive their conscience can be? If you have a Princess and the Pea-type conscience and it's religious, we have to protect that too. So there was no hard analysis on the plaintiff side. But the court was not really as generous to the government. It allowed grudgingly that the government's interest was compelling in providing women with no-cost contraception. And we don't have time to get into that, but the reason for that the government did this was it had done a study finding that women who have unplanned pregnancies actually have worse health outcomes for themselves and for their babies. And so you don't want to have an unplanned pregnancy. You want to know you're pregnant and plan the pregnancy. And that if you provide people with no-cost contraception, they're more likely to get it than if you just make them pay for it, either over the counter or through the health plan. So the court said, okay, the government's interest is compelling, but there was a little snark there. But it kind of undercut the compelling nature by noting that the government had made exemptions for other purely religious groups. The thing about Hobby Lobby was it was a corporation, not like a church, and that it had a staged-in requirement to provide this. So it said, well, I don't know how compelling it is if you're not making everybody do it all the time. But it didn't rest its decision there. It said the government didn't adopt the least restrictive means of providing contraception, even if it suggested at one point that the government, if it wanted these women to have contraception so badly, it could just pay for it itself. I mean, wasn't really impressed with the idea that, well, they'd have to go pass another law for this. And finally, the court said, well, there is a program, a regulatory program that's there that you can fold these people into. So you should do that rather than burdening people with religious objections. So the Supreme Court is interpreting RFRA and is showing extreme deference to people whose religious belief doesn't want them involved in any sense with what they think of as abortifacient drugs. So my third question after this, so the first question is what was the First Amendment? Second question, what's the law? Now I'm on question 3, how is the legal framework changing? Well, if you think about it, Hobby Lobby shapes our imagination, our pattern of expectation about religious freedom. We are used to seeing religious freedom cases, culture war cases, where religion and religious belief means conservative religious belief, right? The religious people are the conservative people. They are the people that are holding on to the traditional values. They are the people who do not want to expand. They don't want to be involved sometimes in same-sex marriage, sometimes in contraception, sometimes in abortion. And in fact, apart from the small, vulnerable people who are still making little claims about religious practice, the Native Americans and ancillary groups, that's come to dominate our religious liberty jurisprudence, although RFRA was originally designed for small minority groups. So we have a situation where religious freedom and conscientious objection are really imaginatively configured on the side of conservative religious believers. Catholics and evangelical Protestants were suing under RFRA because they conscientiously objected to abortion or contraceptive coverage. But on the other hand, as well, federal law, almost since the time of Roe v. Wade, which did constitutionally protect abortion 50 years ago, also protected healthcare providers who did not want to be involved in abortion with very strong federal laws and regulations. Healthcare institutions were not permitted to discriminate against providers or doctors who didn't want to be involved in abortion. So the conscientious right to object was configured, or to follow one's conscience, was configured in favor of religious conservatives opposed to abortion and contraception. That's the imaginary we were in. And it made sense in a sense because abortion and contraception, all of that, were legally protected. So the objectors were more religiously conservative. But things have shifted since Dobbs versus Jackson, right? It's a sea change. As you all know, it overturned Roe v. Wade and returned abortion to the states. By doing that, it's opened the opportunity for a reverse or a flip in who is bringing religious liberty claims, right? Some states permit abortion, some states prohibit it nearly entirely, and others take a middle ground. So this is a mirror image problem with respect to religious liberty. Before, it was people opposed to abortion for religiously infused moral reasons who were objecting to having to comply with permissive laws. Now it is people who support abortion access for religiously infused moral reasons who are objecting to having to comply with restrictive laws. Now, this isn't merely a hypothetical possibility dreamed up by a slightly bored law professor, theology professor, me. Not that there's anything the matter with that. Some religious believers who believe it is morally appropriate and sometimes morally necessary to offer abortion services are now, in fact, claiming their right to religious freedom is being violated by laws banning or restricting abortion. Lawsuits to this effect have been brought in several states, including Indiana, Florida, Kentucky, and Wyoming. And in Indiana, the strict abortion law has been blocked, and the case is making its way through the state Supreme Court. A judge said, you know what? These actually members of the Jewish community, Unitarian Universalists, other religious believers have a point. We have to consider it. So that's the new situation. So how are we going to think about this new situation? Well, I think there are just 4 points that I want to bring to your attention. First, different religious traditions do, in fact, have very different views on the morality of abortion. And one place I would suggest you go is the Pew study on that, which says that, there are certain churches that are very restrictive on it, but there are also churches and other religious believers like Reformed Judaism, Conservative Judaism, Presbyterian Church, Unitarian Universalists, United Church of Christ, the Episcopal Church, the Methodist Church, and Lutheran churches. A lot of the mainline Protestants think it's a morally appropriate choice for both doctors and patients under some circumstances. And they are not simply saying, we don't believe in God, so anything goes. They're saying, given our beliefs and our understanding of obligations to our patients, we think in these circumstances, abortion should be available. And then you may say, well, what about the fact that there are some religious communities that don't believe in abortion? The Catholic Church teaches, that abortion is wrong in almost all circumstances. There are exceptions, but I won't get into them right now. But then if you look at what Catholics think, they're pretty much on the same page as everybody else. They're divided along the same lines as the population. And you may say, well, they can't get abortion because of, their religion teaches it's wrong. Well, the Supreme Court doesn't care what your actual, you don't have to bring a note from your pastor, right? So there are Catholics who interpret their religious faith in a more liberal way, just like there are evangelical Protestants too. So America is a very religious country, and we're a very religious country that's divided over abortion, and people take their religion seriously. Point 2, the current religious freedom jurisprudence, including sympathetic as it is to mainline religious belief, can be made to work in the favor of religious liberals as well as religious conservatives. So just go back to the 2 constitutional law cases I talked about. Employment Division v. Smith says to communities, make the general applicable law that you want, just as long as you don't target religious minorities specifically. You don't need to be afraid about violating the Free Exercise Clause. So that's good for people who want to legislate against abortion, right? Just make a generally applicable law, you're okay. But over time, it has appeared that what the court means by not targeting or discriminating against a particular religion has been getting much more stringent. In a case during the pandemic, the Supreme Court struck down, under the Smith test, COVID regulations that applied to church because they made exemptions for other entities and didn't make exemptions for churches. So if you have exemptions for other kinds of activities and you don't look at the religious believers, it looks like under this new iteration of the First Amendment test, the court is going to look askance at that. Some scholars have said that religious beliefs under this Supreme Court have what's called a most favored nation status. If legislators make exceptions for a general law for other reasons, they have to make them for religiously motivated people as well. So you can have a true law without exceptions, but you start giving different groups exceptions, the religious people are first in line. What about RFRA, Religious Freedom Restoration Act? As I said, that is more protective. And there is language in Hobby Lobby that suggests that if the state grants exceptions for other reasons, you may not actually have a compelling state interest that justifies infringing on religion. So here, kind of Hobby Lobby and the new interpretation of the First Amendment case, Smith, are kind of converging. So if you have rape, incest, health of the child exceptions to your abortion law, why don't you have religiously based exemptions? Those are exemptions. Why not exempt the religion? The fact that people are allowed to travel to other states to get abortions may be invoked as well to show that preventing abortion is not really a compelling state interest. The state's not really doing what it can to make you from leaving. And it gets even more complicated when a provider who lives in a state where abortion is legal justifies providing a medication abortion, writing the prescription in that state to pregnant women in the state where it is illegal, because the provider is the target, and the provider is invoking that person's religious liberty, which is arguably shaped by their home state, not by the state where they're providing the person with the pills. But what about the response that saving the life of an unborn human person has to be a compelling interest? What could be more compelling than that? That's why the law's passed. That's got to be a slam dunk argument, right? No, it's not. And it's part because of the Supreme Court. Roe v. Wade said the fetus was not a person entitled to constitutional protection under the 14th Amendment. Now, when Dobbs v. Jackson overturned Roe, it overturned the whole decision. So what is the fetus nationally now? Well, it's not a person. That's all we know. It's not a person, but that doesn't mean it's a person. Different states may have different views on what it is. Some states are going to adopt personhood amendments. Some states won't. Some states will regulate abortion without touching the personhood issue. And in that situation, I think RFRA's got a very strong claim. Because if you haven't said the fetus is a person, the state hasn't, and the nation certainly hasn't, then the religious freedom claim seems much stronger because you've got a very nebulous claim on the part of the fetal life because it's not a person at that point. So we're really entering uncharted waters with Medicaid abortion and doctors who have a religious liberty interest and patients who have a religious liberty interest in obtaining abortions in accordance with their religious belief. My sense is that there is a good case to be made under religious liberty for protecting providers whose religiously influenced moral views point them toward performing abortions in certain cases. That's my sense. Now you say, well, you haven't even considered the objections. So before we open it up, I just want to give you the 4 objections. Do I have time for that? Are we okay? That the pro-life side might take, because I think it's really important when we talk about these issues not to only talk about them from one side and do the best you can to consider everybody's objection. So many religious conservatives will balk at my argument. As I see it, they will have 4 objections. They will say, well, look, there's a big difference between refusal to do something and having a claim to do it, right? One might argue that the case of conscientious objection to abortion is refusal to do something that you object to, while claims of religious freedom to perform an abortion is a claim to do something. But that distinction doesn't hold a lot of weight in First Amendment case law. In fact, the Smith case itself, which provoked the stringent response in RFRA, involved a case where the Native Americans actually wanted to do something, right? They wanted to smoke peyote. They didn't want to just not smoke peyote and look at it. Then they may say, well, there's a big difference between following a religious prohibition. We're prohibited from performing abortions and claiming a religious permission. And that distinction doesn't work either. The case law, which doesn't protect behavior that is religiously required by faith only, but also religious behavior that is in accordance with one's tenets, of the tenets of one's religious teaching are encouraged. In this case, religious believers who think it's an act of justice toward women that expresses their religiously infused set of moral obligations. So maybe they're not going to go to hell if they don't do the abortion, but they feel a religious call to engage in this behavior as what's in accordance with their conscience. A third way the pro-life people might try to get around this is by saying, it's important to give pro-lifers exemptions to pro-choice laws because their objections are religiously infused moral objections. But that when pro-life laws are enacted, the religiously based objection of people who support abortion doesn't count because they are really secular people. You know, there's a lot of talk in conservative circles about how the only real religious people are the religious conservatives, right? Because they're the ones who are holding on to the teaching and everybody else is just giving in to the broader culture, so they don't count. Well, the trouble with this argument is that it doesn't take seriously the religious beliefs of our fellow citizens, right? It chops them up on the Procrustean bed of liberal versus conservative, where only conservative can be religious. And that's just not in accordance with the facts. Moreover, in our increasingly pluralistic society, it's the case that religious freedom should be read to include the sincere claims of conscience, not just organized religion's conscience. In fact, this was the United States versus Seeger. It interpreted cases involving a statute, not the First Amendment, but the court said sincere beliefs in accordance with a worldview, a settled worldview, whether or not that worldview was traditionally religious or not, needed to be protected. The fourth objection I call heads I win, tails you lose. There's the argument that while laws protecting or requiring participation in abortion violate religious beliefs, laws prohibiting abortion are simply moral laws, full stop. They do not impinge upon anyone's belief, but reflect common morality. Very often, advocates of this point of view point to the fact that fertilization marks the beginning of a new distinct life. Their view, so they say, is science-based rather than religion-based. But there are also two problems with this argument. The first is the fact that deciding at what point in pregnancy a distinct human life begins is very problematic. Even among pro-lifers, some say fertilization, where the egg meets the sperm, but others say it's the end of the tatipotent phase, where the possibility of twinning or recombination occurs. Because if you have something that can reproduce asexually or combine, it's clearly not a full human being yet, because it's behaving more like a cell than like a person. So I think that we've got a problem there in terms of, there's a lot of debate about when personhood begins. The Supreme Court didn't resolve it. But second, and more broadly, it's not a recipe for a stable political life. For powerful religious traditions to say, when I lose the popular vote on abortion, you need to protect my conscientious views, but when I win the popular vote, I don't need to consider your views at all, is not a recipe for a common life. It is heads I win, tails you lose. So what do we do? Where do we go? Well, let's go back to the almond joy to think about religious liberty, or the three-leveled circle. I'm very sympathetic to protection for expression of religious belief, the deep core of religious liberty, the blue circle, the almond. I'm also sympathetic to greater but not absolute protection in the context of religious ritual, the coconut level or the purple level, right? Because ritual contains action, right? You're saying I can smoke peyote here, but not at the beach. So there's a container. But I do think in a pluralistic society, a general view along the lines of Smith is about as far as we can go. It's up to us to decide as citizens and lawmakers how to determine what we're going to do about controversial moral questions that have religious resonances. This means two things. We shouldn't try to derail arguments by saying, on the one hand, the argument doesn't count because it's religious, or on the other, it deserves special protection because it's religious. And second, rather than asking what are my rights under the free exercise protections, which can seem greater because, of course, I'm right, I think we need to ask, what do we owe other people of good faith who disagree with us and whose conscience we want to protect, under the basic rule of religion that applies across faith, the golden rule, do unto one another as you would have them do unto you. So that's not an answer to this set of questions, but I think it's a way of explaining where we are in religious liberty and the Dobbs decision, and also maybe giving us a new way of thinking about what we should do going forward. Thank you. Thank you. Wow, somebody's standing.
Okay, we do have time for questions, so if you would, please raise your hand, introduce yourself, and we will get them started here. Okay, please.
Hi, my name is Mary Jordan. And you mentioned that there were lawsuits that have been filed in 4 states, and I remembered you said Indiana, Kentucky, Wyoming, I don't remember the 4th. Florida. Okay, and so can you elaborate on the claims that the plaintiffs are making about why they should be allowed to have an abortion?
Okay, so it's under RFRA, it's the Religious Freedom Restoration Act, and what they're claiming is that these laws that stop them from having an abortion or performing an abortion count as a substantial burden on their religious beliefs, because their religious beliefs do not see unborn life as having the same weight, and they, in some cases, they believe, especially in situations like there were in some of the Jewish cases, Ashkenazi Jews are subject to certain genetic risks that are higher than the normal population, and they believe, and the babies can be born, and lead very suffering lives and die very young, and they believe they have an obligation under certain circumstances to prevent the suffering. That's what
back here.
Joan McGregor, is that on?
Hi. Yes.
Hi. Okay, I'll just talk loud. I really like their analysis of where we can go with the Dobbs decision. But I wanted to go back to the Hobby Lobby case, because it really bothers me that this idea of conscientious objection can be taken to be, the way the Hobby Lobby decision was made. I mean, we now have seen, pharmacists object to giving out, abortifacients, and I guess even the day after pill, right?
Morning after pill, yeah.
Yeah, and and that's somebody handing somebody something. So there's like the nexus is a little closer, and I understand, not requiring physicians to perform abortions. I can understand, and this has come up in the end of life cases of in states that have physician-assisted death. But in these cases where the nexus is so remote, I mean, it seems to me that we could raise all sorts of objections to how my funds are used against things that go against my religious belief.
I agree with you. I mean, in Catholic thought, it's called cooperation with evil is the framework. It sounds really, kind of spooky. But it's really about, how close you can get to somebody else's wrongful action without being tainted by it yourself. And it's actually very sensible as the church talks, about it in its, in its context. So there's a big difference between covering something in an insurance company and actually doing it yourself. It's what the tradition would call remote material cooperation with evil justified by proportionate reason, which means, it's a shame, but you got to do it. They need the health insurance. So the problem with that is that, Alito didn't, engage in any of this kind of difference between direct action and, you could call it remote complicity analysis. And I think that that's caused a lot of harm. And I think that's because there's this notion of purity. I mean, I actually think the religious ritual, I need to be pure and I need to not be touched by any of this. I can't be engaged in this. But then you think, well, why don't you write a contract and require your employees not to spend their money on, I don't know, what you don't like? I mean, you could do that, but eventually we're going to get to a point where we're going to not respect the different spheres of our own lives, right? That an employee doesn't own you. An employee isn't your parent. An employee isn't your guardian. And, you don't have a right or a duty to stop your employee from behaving in ways that you don't agree with in a pluralistic society.
Hi, my name is Paul Gary. I'm just wondering, is this, the argument you're making about using the Religious Freedom Act on the liberal side, is that a somewhat limited argument, though? Because you're really not, or maybe you are. Are you talking about the situation where, in family planning, a family says, we just can't afford another child. This was a mistake. We tried to stop it. It didn't happen. And now we're stuck, and this is going to be a terrible burden on our family. The religious freedom exemption is not going to apply to those types of situations, is it?
Well, it's really interesting. It depends on how they frame it. I mean, if you argue, I'm a member of a Reformed Jewish community. The Jewish community for a long time has taught that human life does not actually begin until birth. That's when you get the status of an equal human person. I accept that belief, and I have to make my judgments about what to do in accordance with that belief. And Jewish thought also emphasizes the well-being of the mother and the family. And so I feel like I have a religious obligation to do this, that I think you can run a religious liberty claim. Now, don't get me wrong. I'm not saying that this Supreme Court or a lot of these, are going to take them. But I think we're going to end up, if they don't actually consider them well, where we're going to have two classes of religion. The good religions and those, kind of little lefty liberal religions that just might as well go straight to the secular world. And I don't think that's true, and I don't think it's good for the community, even if you have disagreements about abortion. They're very sincere, and they're divided on religious lines. Anybody else? Yes, Tracy.
Thank you so much, Kathy. Tracy Fessenden. Listening to your wonderfully vivid description of the almond joy and the almond at the heart of all of this, I'm thinking that one huge difference for me, and I think this is why Hobby Lobby was so troublesome, and now Dobbs so troublesome for many of us, is that Smith and Reynolds and Seeger involve a person who wants to do something that lots of people think is not okay. Drink, smoke peyote, not go to war, have multiple partners, in marriage. But their doing that thing doesn't really affect large numbers of people. And with Hobby Lobby and Dobbs, I'm all for the Greens, the Hobby Lobby CEOs, having their rights of conscience. I'm all for the Supreme Court justices having their freedom of conscience. But these are situations where the call to conscience of these extremely powerful folks has removed a right from half the population. And I just don't see where in the analogy of we can believe what we want, we can associate with whom we want, we can practice rituals in a contained way, we can even advocate for the legality of our practices that break general laws. Where in that model, where in what you have presented us with, is there help to understand how it's possible for for what conscience enjoins some very, very powerful people to drastically curtail the liberties of half the population?
Right. I think that gets beyond, that's a wonderful question. I think it gets beyond the religious liberty question to sort of a general sense of how the court is made. On the Hobby Lobby case, part of what worries me is I don't think conscience and money should go together, right? So, they do go together. We should be more conscientious about how we use our money, no matter how much or how little we have. But the Hobby Lobby family, the Greens, are able, because they are so financially successful, to shape the conscience, the decisions, that are made by their employees. And I think looking at, what is the legitimate possibilities of having money? What can you do versus what is not a good thing to do if you're a rich person with a business, with respect to the independent lives of people you work for. So that's for me a big problem about that. The other thing is I think we just have to realize, Roe had some problems too, right? Roe was a decision that was received as a bolt from the blue by half the population. The population's view of abortion has not really shifted over 50 years. There's some people on either side, and there's a large muddled middle. And what was going on, even Ruth Bader Ginsburg noticed this, was a reform of the abortion laws, sort of state by state, to try to take into account, new circumstances, the rights of women, other things. And the Supreme Court just upended that, striking down abortion laws in 45 states. And that is what created the culture war. So if the process had continued in a more normal way, my bet is we would have ended up with something like Europe, with a reasonable period for people to make a decision, exceptions for later, abortions under very, difficult circumstances, life, health of the mother. And we might have come up with a compromise that people could live with. But we had a culture war instead, and what that culture war gave us was a whole theory of constitutional interpretation, originalism, textualism, that was designed precisely to overturn Roe. And that's why the justices, the last set of justices under Trump, were put on the court, and they did what they were expected to do. And, you know, frankly, they did what they believed as well. I have no doubt that they believed it, but I think they've created a number of problems for other of their issues, like religious freedom, because I don't think they thought through. I just don't think they think that religious people can be in favor of abortion under certain circumstances.
All right, I think we're going to bring this to a close. Before I do, I just want to remember and observe again how important the legacy of the Marshalls' gift has been. Well after their passing, it has made it possible to bring Professor Kaveny here to speak with us and impart her wisdom and really give us a lot to think about, to go home to continue to mull over, and maybe to think about as we discuss these things with friends who have different views than our own. So I want to thank you especially for that, and I want to thank all of our donors who make possible the kind of work that we're doing here. And if you would like more information about that, please let us know. We can help you. So with that, I'd like to adjourn today, invite you to head downstairs to the reception in the bistro, but not before offering one last applause and round of applause to our speaker today, Cathleen Kaveny.